This is your Section 2 podcast where we explore intestate succession. The statute for intestate succession is found at 755 ILCS 5/2-1, and it's titled Descent and Distribution. Descent and Distribution. And that should be apparent if you've taken a look at the statute. Typically, property descends or it's distributed out. But as we see in the statute, it could also go back up through your family tree under certain circumstances. In a nutshell, that statute is intended to recognize that if you die without a will in Illinois, your assets will go to your closest relatives under that statute. And I'm going to offer some details as to how intestate succession works in Illinois. Only assets that would have passed through a will are affected by intestate succession laws. Usually that includes only assets that you own alone in your own name. Now, many valuable assets don't go through your will and aren't affected by intestate succession laws, and here's some examples. Any property transferred to a living trust, life insurance proceeds, funds in an IRA, a 401k, or a retirement account, securities held in a transfer on death account, real estate held by a transfer on death deed, like the different tendencies that we learned about in the first week when we reviewed property, real property. Payable on death bank accounts, or property you own with someone else in joint tenancy by the entirety. Those assets will pass to the surviving co-owner or to the beneficiary you have named, whether or not you have a will. For anything else you own, the statute provides that if you die with children but no spouse, the children will inherit everything. If you have a spouse but no descendants, the spouse inherits everything. A spouse and descendants, the spouse inherits one half, and the descendants inherit the other half, split equally depending on how many people are in that descendant category. This is a spouse would get half. If you have two children, the two children would get a quarter each. If you have parents but no spouse, no descendants, no siblings, the parents would inherit everything. If you have siblings but no spouse, no descendants or parents, your siblings inherit everything. If you have parents and siblings inherit your estate, property, in equal shares, except that if only one parent is living, that parent gets a double share. So in other words, if your father has passed, your mother survives you, and you had 3 siblings, there would be your property divided up into fifths, percentages of 20, and your mother would get 40%, and your siblings would each get 20%. In Illinois, if you are married and you die without a will, what your spouse gets depends on whether or not you have living descendants, children, grandchildren, or great-grandchildren. If you don't, then your spouse inherits all of your intestate property. If you do, they and your spouse will share your intestate property 50-50. So the spouse will get 50%, and then those descendants will get 50%. and that's referred to as the spouse's share. The children's share, if you die without a will in Illinois, your children receive an intestate share of your property. The size of each child's share depends on how many children you have and whether or not you're married. For children to inherit from you under the laws of intestacy, Illinois must consider them your children legally. For many families, this is not a confusing issue, but it's not always clear, and here's some things to help you understand what legally recognized children would be. Adopted children. Children you legally adopt will continue to receive or will receive an intestate share just as if they were biologically children. Adopted children are the same in the eyes of the law as biological children after a legal adoption. Foster children and stepchildren, never legally adopted, will not automatically receive a share. Children placed for adoption and who were legally adopted by another family will not receive a share, unless the decree for adoption specifically provides for continuation of inheritance rights. If, however, your biological children were adopted by your spouse, that won't affect their intestate inheritance. In other words, they're your biological children. Your biological children still have intestate succession rights. If your spouse, their otherwise step parent, adopts them, which happens. Posthumous children, children conceived by you but not born before your death, will receive a share. Children born outside of marriage, if you are not married to your child's mother when she gave birth to them, they will receive a share of your estate if you acknowledged your paternity or if during your lifetime or after your death a court establishes paternity. Artificial insemination. A child born through artificial insemination after your death will receive a share if you consented in writing to the use of your biological matter and the child is born within 36 months of your death. I'm not aware of any such case, but grandchildren. A grandchild will receive a share only if the grandchild's parent, your son or daughter, is not alive to receive his or her share, and that just follows down through the statute. If you die without a will and don't have any family, your property will what we term escheat, ESCHEAT, into the state's coffers. People sometimes fear, well, if you don't have a will, your property is going to go to the state. Well, no, if you die without a will and you don't have any family that the intestate succession statute can lead that property to, and there's an exhaustive search, that property will end up in the state coffers. However, it's very rare. Rarely happens because the laws are designed to get your property to anyone who was even remotely related to you. For example, your property won't go to the state if you leave a spouse, children, grandchildren, parents, grandparents, siblings, nieces, nephews, cousins, or great-grandparents. So it's a rare case when property doesn't get passed to someone and that it goes to the state. Here are a few other things you should find worth knowing about the Illinois intestacy laws. The survivorship period. To inherit under Illinois intestate succession statute, a person must outlive you by 120 hours. So if you or your brother in a car accident and he dies a few hours after you do, his estate would not receive any of your property. Half relatives. Half relatives inherit as if they were whole. That is, your sister with whom you share a father but not a mother has the same right to your property as she would if you had both parents in common. And many of us have half siblings. It's not an uncommon thing. Posthumous relatives. Relatives conceived before but born after you die inherit as if they had been born while you were alive. All right, so that's your children, grandchildren, etc. Immigration status. Relatives entitled to an intestate share of your property will inherit whether or not they are a citizen or legally in the United States. Kind of timely. Someone who intentionally and unjustifiably kills the decedent, the deceased person, will not receive a share of the property, even if the intestate succession statute would have lined them up to do so, to receive that property. So you can't kill somebody and get their property. Makes sense, right? For the elderly or disabled, if a person commits certain offenses against the elderly or disabled, primarily those involving exploitation, abuse, or neglect, and they would have otherwise received a share of that individual's property through the intestate succession statute, they will not. Okay, if they exploited, abused, or committed neglect upon an elderly or disabled person, they are going to be prevented from receiving any property from that individual through that statute if they die, as they likely would have had a challenge if there was a will. And advancements, if you give property to a relative during your lifetime, the value of the property is subtracted from your relative's share only if you wrote this down at the time of the gift or your relative admits that this is the case in writing. This comes up on occasion because families will kind of get into tiffs about property after the loved one dies, and that happens whether there's a will or not, about things that were given to an individual prior to the death. And it's not uncommon that someone say, I'll just pick a common thing that happens is as a person becomes older and they stop driving, they give their vehicle that is a little older vehicle, long paid off, no debt on the vehicle, to one of the relatives. Unless that was something that was written down as being an advancement on that individual's share of either the intestate succession statute or a share of the will, that's not how the law is going to view it. So those are some things to think about regarding intestacy and the intestate succession statute, and hopefully clear up some of the misinformation that people have about wills and whether you have a will, whether you have a valid will, etc. Now, ideally, you have a up-to-date, valid will. But when we get to drafting wills, we'll talk about how there are often problems there as well. The main point is that if you die without a will, all your property doesn't go to the state. There is a comprehensive, I like to refer to it as a will provided by the state in the statute. It provides some avenue for you to have your property go to people who are related to you. And as I said earlier, in rare occasions would that property go to the state. And the IDA agrees with me that, or he wants some food. So that's section 2. Legal 115 podcast. If you need me, you know where to find me.